Court's now in session. You may be seated.
Can we have Mr. Johnson brought in, please? You are on a starting today with the Commonwealth versus Myles King, indictment 2021-0320. Mr. King is represented by Attorney Rosemary Capiccio. Bianca Ciancio, indictment 2022-0265. Ms. Ciancio is represented by Attorney Joe Cataldo. Giovanni De Los Santos, indictment 2022-0267. Mr. De Los Santos is represented by Attorney Joe Kowski Jr. Sean Johnson, indictment 2022-0268. Mr. Johnson is represented by Attorney Rosemary Capiccio. And Commonwealth versus Brian Walsh, indictment 2023-0091. Mr. Walsh is represented by Attorney Larry Tipton and Attorney Kelly Porges. Counsel for the Commonwealth is ADA Lisa Beatty, and is available?
Well, good afternoon, Your Honor. Lisa Beatty for the Commonwealth. I'm present for the first part of it, and then to the extent that the individual cases need to be addressed today, the individual assistant DA assigned to the trial team will appear.
Great.
And Judge Rosemary speaking on behalf of Mr. Johnson and Mr. King. I'm also standing in for Joe Kowski Jr., who's on trial in front of Judge Dupuy down in Fall River, and I believe that Joe Cataldo's client was excused. Yeah. And I indicated that if he could not make it, I would stand in to him as well, Judge.
All right. I think Mr. Tipton indicated that he had some issue today, and
Happy to stand in for Mr.
I think he was.
I thought he was going to be on Zoom.
Do you think he was going to be on Zoom?
Oh, okay.
Oh, Joe, right here. Mr. Cataldo's walking in.
Okay.
But I thought that either Mr. Tipton or Ms. Porges was going to be on Zoom.
I'm not seeing either one of them.
I'm happy to stand in and report, Judge.
Okay. Ms. Beatty, where do things stand?
Your Honor, I can report to the court that we have completed our review and we are in continued conversation with the U.S. Attorney's Office. I recognize that that's not a lot of information to provide to the court, but that's the extent of the information that I have for today.
Have you come to a conclusion that certain information supplied in the confidential information should be turned over in these cases?
All I can say is that we are in conversation with the U.S. Attorney's Office as a result of our review.
All right. Well, your review is the threshold for having conversations. So if you're having conversations, it must be that you have made a determination that certain information needs to be turned over. And what am I missing? There's no hide the ball here. If you think that certain information should be turned over, you would have conversations with the U.S. Attorney's Office and maybe would have to go to the court if the U.S. Attorney's Office doesn't acquiesce.
Because of the order, I'm reluctant to comment further in open court and at this stage. And so on the advice of counsel at this point in time, that's the statement that I feel comfortable giving. In no way am I implying to the court that I will refuse to provide further information at any point in time. Just for today's purposes, that's what I feel comfortable disclosing to the court.
I don't recall any provision of the order that would bar you from disclosing whether you think anything contained in the confidential materials should be disclosed. Maybe I missed it, and I didn't go back for purposes of this hearing to review, but you were authorized to do the review, but I don't think you are barred from sharing whether you think certain information, not what the information was, but that there existed among the confidential materials certain information that should be turned over in certain cases. You read the report differently, the federal order differently?
So there's a series of orders, and I'm just trying to be cautious. If you want to give me a second call, I can consult with our counsel. But I guess my question to the court also is depending on, how fully we answer that question at this point in time, I'm trying to figure out what the next steps are for this court's purposes.
Right. If you answer the question, we've reviewed the documents and there is nothing contained in the documents that needs to be turned over, that's one response, and that's one response that this court will have in terms of scheduling. But if your response is there are certain things that should be turned over, or that's our assessment, then under the federal order, you'll have to go to various places to get authorization. If you're doing that, defense counsel would have an interest in seeking to join that effort to liberate the documents for disclosure, and so that's why your initial assessment, which I don't think is covered by the confidentiality order, protective order issued by Judge Casper, the most recent iteration that liberalized it and allowed you to do this evaluation, I don't think it covers that threshold question of yes or no, not the substance. So I'm happy to put it on for a second call. You can take a look. Everybody can take a look at the order because everybody subject to the protective order has those orders now, and you can have a discussion about that if you like.
I agree with the court in terms of the interpretation. I thought we were here today because the Commonwealth was taking that initial look. That's why we gave.
They did take the look, and that's what Attorney Beatty is saying, that they have taken the look, but at least the threshold question she felt right now uncomfortable telling us whether it was the Commonwealth's view that certain information should or shouldn't be turned over to the defense. I haven't gone back to look at the order. You folks should. You can actually compare interpretations if you want, have a discussion, and then I'll see you again.
Thank you.
Second call.
Matters held for further call. Number 5 on the list, Commonwealth versus Tatiana Cosme, indictment 2021-014, scheduled for an initial probation surrender. Probation is represented by P.O. Rachel Boyce. Attorney Anzalatos has been kind enough to say he will step in and represent the defendant. Counsel, Madam Officer, if you could identify yourself, please, for the court and the record.
Good afternoon, Your Honor. Rachel Boyce with probation.
Okay.
Good afternoon, Marcy Anzalatos, on behalf of Ms. Cosme, and I'll accept the appointment.
Thank you. We will appoint CPCS for that.
I think this is on, I don't know if there's been an initial, I do want to raise a probable cause issue.
Let me just see if I can understand what's going on here.
Sure.
I can explain it, Judge, if you're...
Cosme is on probation for a trafficking charge, or?
I think she's on probation for the conspiracy.
Oh, conspiracy charge, okay. And she recently picked up a new charge of larceny over $1,200.
Correct.
And that was, looks like it was arraigned in August, early August.
Yes, Your Honor.
And, all right, what do you ask me to do?
We were here August 14th for an initial surrender hearing, but we could not go forward that day because there was no duty attorney available. Okay. So today we're back here for an initial surrender hearing. I'm asking that she be released on personal and we get a 30-day date to come back.
Mr. Anzalatos?
So I just got the paperwork today. I did want to be heard on probable cause. I could either make an argument today or we could pick a date for further initial where I could file something. The short version is, if you read the application for complaint in the new case in Dedham, and it hasn't been subject to a de Benedetto proceeding there yet, as far as I can tell from the docket. I don't represent her in Dedham. There was a bail posted actually in the case that my client's on probation for. The bail slip was in her name. She retrieved the bail. Her ex-boyfriend, who's also the co-defendant in the drug case, family member, mother, is accusing her of taking that money when in fact it was the mother's money sort of lent to her to post bail. If you actually dig through the statement of facts, what it sounds like really happened is that the mother went to the police station to bail both of them out, couldn't stay and wait for the bail commissioner, and allowed the slips to be put in their names. Based on my understanding of the law, at the moment that she's handed the money over and put it in the name of Ms. Cosme, that slip, for all intents and purposes, becomes a bearer instrument. It's like signing over a money order or signing over a check or signing over everything. I don't actually believe any of the allegations, but even if the allegations in their entirety are believed, it's a civil matter. She lent money to someone and that person is allegedly not paying her back. That's not larceny by any stretch of the imagination. And in fact, Ms. Cosme, I'm sorry, not Ms. Cosme, but the complainant, in somewhere in the back of her head,
Larceny is what? The taking of property belonging to someone else with the intent to permanently deprive the person of the property, right?
So if someone gives you their property and says, well, you give it, you have to pay me back, that would mean every loan that was unpaid is a larceny. It's just not, which is why the complainant has an ongoing case in small claims court, because she knows this.
I think it's glib to say that every failure to pay back a loan with the intent of permanently depriving the money, the other person who loaned the money, of the money, is not a larceny. I think, it may well be able to be charged as a larceny. It may be a civil matter too, but much depends on what the back and forth was between the person who posted the bail and the other person. In any event, I think what we'll do is we'll put this on for 30 days, see if it can be resolved. And if it can be resolved, great. Otherwise, we'll have a hearing. I think we can put this on for a final.
That's
Yes,
fine.
fair enough.
I'm sorry, you told me the days and I already forgot. Monday, Tuesday, and Thursday.
And Tuesday doesn't work for us.
So I can do Thursday the 16th.
October 16th?
Yeah.
That works.
Okay, great.
Sure.
Final surrender, October 16th.
Thank you.
Okay.
Ms. Cosme, Attorney Insulatos has been appointed to represent you in this matter. Your matter is continued to October 16th at 2 p.m. Stay in touch with Attorney Insulatos.
Okay, thank you.
You're all set.
Thank you, Your Honor.
Your Honor, number 7 on the list, Commonwealth versus Charles Martin, indictment 2022-0125. This matter is on for a final pretrial conference. Mr. Martin's present in court with his attorney, George Olson. Have we seen Mr. Olson? Oh, there you go. And Commonwealth by Michael Gaffney, Mr. Olson and his client.
Okay, Mr. Gaffney, I've received a motion to dismiss the indictment.
Yes, Your Honor. One indictment
With
three
prejudice?
counts. Yes.
Any objection?
No, Your Honor.
Anything else holding your client?
No, Your Honor.
All right. Mr. Martin, you are free to go. I'm granting the Commonwealth's motion to dismiss the indictment with prejudice. Okay?
Thank you.
All right.
Case dismissed. Number 8 on the list, Your Honor, Commonwealth versus Tasha Hayes, indictment 2022-0159. Mr. Nelson was kind enough to say he'd accept appointment on this matter. Commonwealth is represented in this matter by ADA Joe Martinelli. Mr. Nelson and ADA Martinelli are present in court, as is Ms. Hayes. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good afternoon, Your Honor. Joe Martinelli, Commonwealth.
Okay, Mr. Martinelli.
Robin Nelson, Ms. Hayes.
Okay, Mr. Nelson. Mr. Nelson, Mr. Silverman had represented Ms. Hayes. There was an issue with respect to their ability to get along, and I appreciate you being willing to take the representation. Ms. Hayes is scheduled for trial on the 23rd. Is that right, or next week? I guess.
It was originally tomorrow.
Oh, it was originally tomorrow. I'm sorry, tomorrow. And this is an old case, so we're going to put this on for trial sometime very soon, after you've had a chance to get up to speed. So I'd like to set a trial date, understanding that you haven't gotten, maybe you have. Mr. Martinelli, have you provided the discovery to Mr. Nelson?
Not as of yet. I can get it to him by the end of the day.
Okay, great. So we're going to schedule a trial date sometime soon on this. What I was thinking is we put it on for a couple of weeks.
That's fine.
From now to set the trial date, but it'll be before the end of the calendar year. So when will you be back? What's convenient for you in terms of coming back? Before the end of the month. How's the 25th of September? Or 26th?
26th.
I'm not available the 26th. I would be available the 25th.
24th?
Oh, the 25th is a problem. 24th will not work. Actually, the 26th isn't going to work either. How about the 29th?
I'm away that week.
You're away that week. How about the 22nd?
That's fine.
Monday, the 22nd?
Sure.
Okay, great. 22nd at 2 p.m. You'll have to be back at that time, Ms. Cosme, and we'll be picking a trial date before the end of the calendar year. Okay?
Your Honor.
Very good.
Is that trial assignment?
It'll be for trial assignment, yes.
Matters continued to September 22nd at 2 p.m. for trial assignment. Thank you, Mr. Nelson. Thank you, Mr. Martinelli.
Thank you.
Your Honor, number 13 on the list, Commonwealth versus Marcus Isidore Souza. Indictment 2023-0307. Mr. Souza is present in court. He's represented by Attorney Sarah Westra, Commonwealth by ADA Emily Farley. Counsel, starting with the Commonwealth, please identify yourselves for the court and the record.
Good afternoon, Your Honor. Emily Farley for the Commonwealth.
Okay?
Good afternoon, Your Honor. Sarah Wester for Mr. Souza is present tonight.
Okay. Go ahead. Where are things?
Your Honor recently issued a ruling allowing counsel's motion to suppress with respect to indictments 002 and 005. In light of that decision, the Commonwealth is entering an all press on those two indictments.
Okay. And the other counts, 1, 3, and 4?
The Commonwealth is able to proceed on those.
Okay. So we just need to schedule a trial date?
A motion to suppress. There are two additional motions to suppress that were unrelated to the motion to suppress that we already litigated. One has to do with the,
We litigated things piecemeal?
it
Doesn't sound like my style.
certainly, Your Honor. We filed the motion to suppress that Your Honor heard to be able to move the case along. In the meantime, getting the poll camera footage took a while. I obtained it. It's a 30 days of surveillance video.
So when did you file this motion to suppress?
If the court wants to, I was speaking with the Commonwealth about either selecting a filing date.
Oh, you haven't filed the motion to suppress you're referring to?
That's correct.
Oh, okay. All right.
So there's two motions to suppress that need to be filed. The primary one is requesting a Franks hearing based on the poll camera footage, the warrant that they obtained, and then a separate motion to suppress, which is just a standard four corners motion to suppress that I realized also needed to be filed while I was drafting the request for the Franks hearing and that motion to suppress. So that's where.
All right. When did you get the poll camera footage?
It was a few months ago. I went personally down to the DA's office and picked it up. Then I needed a PC, and it's a few months ago, Your Honor. I don't have like the exact date with me, but
right.
I have gone through it all. And I'm very close to finalizing the Franks hearing motion to suppress. But as I mentioned, I also realized, well, in the process of drafting that, I need to also file a four corners motion to suppress the original warrant, because there were 3 warrants. And that I can have that accomplished.
When do you expect to file that?
I would like to have them filed by the end of this week.
Okay.
Ideally.
I'm going to set a schedule for that. So I want to know realistically when you can file the motions that you're referring to, because it's my general practice to litigate all the suppression motions at one time. I understand things happen. I understand things trickle out. And but let's schedule it for filing and a hearing date soon after for anything that we've got to hear.
May I have September 30th for a filing date?
For filing, so that's, all right. September 30 for filing. And let's get a hearing date. October 17, this will be non-evidentiary.
I'm away that entire week.
Okay, 20th? 21st?
I could do the, are we talking at 9 a.m. or 9 a.m.?
The 21st, we're talking at 2 o'clock.
I can do the 21st at 2.
21st at 2, non-evidentiary, motion to suppress, Four Corners.
Your Honor, is it possible to do the 22nd, 3rd, or 4th?
Yep, we could do the 22nd.
That's fine. But Judge, as far as the hearing, part of the motion to suppress, I'm requesting an evidentiary hearing on the Franks motion.
I'm sure you are, but there's a threshold you have to meet, and so that'll be for why we're scheduling that hearing, okay? So everything that we have to resolve at this first hearing will be on the papers. And I'll take a look at the papers, and we'll figure out if we need an evidentiary hearing, and we'll schedule it. Okay? Which is one of the reasons why I could do a hearing well before the 22nd. If you're going to file these papers by the 30th, we could do a week later. What do you think?
I'd like a couple weeks to look at it.
Okay, so we'll leave it on the 22nd, because you're going to be away somebody's going to be away that week. So 22nd at 2 o'clock for a hearing on the one Four Corners motion and a Franks non-evidentiary.
May Mr. Souza's presence be excused on the filing date?
I'm not even going to have the filing date. It's an out-of-court filing date.
Understood. Thank you.
It's a deadline, but you're setting it, so you've got to meet it. Okay, anything else? All right, we will see, though, on the 22nd of October at 2, okay?
Matters continued to October 22nd at 2 p.m. for hearing on a request for a Franks motion and a non-evidentiary motion to suppress. Thanks, everyone.
Thank you, Your Honor. Thank you, Madam Clerk.
Your Honor, number 15 on the list, Commonwealth versus John Emmanuel McNeil, indictment 2025-24-0232, presented on for a pretrial hearing. Mr. McNeil is represented by Attorney Rich Neely, who I have not seen today. And the Commonwealth by 88 Adam Stewart. John McNeil? Oh, great.
McNeil, Mr. Stewart,
I'm
okay.
scheduled for a pretrial hearing this day, Your Honor. Counsel, starting with Commonwealth, kindly identify yourself for the court and the record.
Good afternoon, Adam Stewart for the Commonwealth.
Okay.
Richard Neely from Mr. McNeil.
All right. Mr. McNeil, you're welcome to sit if you want. You don't stand through the hearing. Mr. Neely, are there any motions that have to be heard
Today, no.
today? What's the story in terms of discovery?
I'm sorry, go ahead.
So discovery from the Commonwealth's perspective is just about complete. There is Your Honor may recall on the last date, there was potential privilege information identified on the cell phone extraction of the defendant. And so I had filed a motion for a protocol to handle that. Recently, there was some issues with defense counsel being able to access the files, so I worked with him through those tech issues. And he recently filed his privilege log related to the cell phone extraction. It's a handful of what appears to be, from what I can gather from the pleading, reference to call log entries on the cell phone, as best I can tell. I don't have any issues with those being sort of segregated and a new extraction completed, but I obviously can't look at the phone to see what those entries are under the current protocol. So I don't know how the court would like to proceed as it relates to those.
Did I issue an order establishing a protocol?
So there was a protocol through which defense counsel would file a log along with any items.
No, I didn't
Correct.
approve the protocol?
No, it was
Correct.
Judge Halal, who's...
Judge Halal did.
Yeah.
Oh, was it? That's right.
Okay.
My apologies. And so under the protocol, defense counsel would review, produce a privilege log along with copies of those items. We have the log. I know Attorney Neely indicated in his pleading he wasn't able to extract the items, but I think we essentially can stipulate that those items for now are privileged and I can have them extracted and have a new extraction redone, removing those items.
So why doesn't that solve the problem? You don't need access to them. You're stipulating that they'll be removed and you won't have access to them.
Correct.
Okay. So
But under the current protocol, it was the court would have to order that they are privileged after reviewing them, but obviously the protocol is slightly different given the technical difficulties that defense counsel has had.
Sue, can I trouble you for that order if we've got it? In the McNeil file?
The order should be paper 8.
Paper 8?
I believe so.
8. Thanks. All right, so I'm looking at paragraph 2 of the order. It says the court will review the privilege log and associated data in camera and make a privilege determination. The privilege log will be subject to a protective order, et cetera. Can somebody turn off their phone? All right. So you're stipulating that the material that's been identified by Mr. Neely is subject to privilege and that paragraph 2 is unnecessary. So assuming that paragraph 2 is unnecessary, and the court will presume, at least for present purposes, that the material that Mr. Neely's designated is subject to a privilege, and you're off to the races, right?
So then I'll have to have the phone sort of filter those out, re-extract it, and then produce a copy to counsel, as well as have one now for myself to actually be able to review.
Right. Any reason that isn't sufficient?
No, it is sufficient.
Okay. All right. Do I need to do anything more, Mr. Stewart?
At the current time, as it relates to that issue, no.
Okay. So that's how we'll proceed. I'll presume that what Mr. Neely has designated is privileged, and you're good to go. Then the question is next steps.
Next step would be filing of a motion.
Motion for in what?
Suppress.
To suppress what?
The results of the execution of a search warrant of Mr. McNeil's home.
Okay, and is that a Four Corners challenge or?
Yes.
Four Corners? Okay, when do you want to file it?
How about the first week in November?
November?
Yes.
That seems kind of far away.
Last week in October?
You're a tough negotiator. All right, yeah, let's say filing by October 27, Monday, October 27, out of court date, and I'll have a hearing the week of November 10. How's the 13th?
13th is good for me.
Would that be at 2?
Yep.
Yes, I can do 2 on.
Four Corners Challenge hearing at 2 o'clock on the 13th.
Will we be on the list for the 27th or?
Nope, that'll be an out-of-court filing date. Do I need to make it an in-court filing date?
No.
I mean, no, you'll file it up by the 27th, and we'll have the hearing on November 13th. Okay?
Yes.
All right.
Now, this continues to November 13th at 2 p.m. for a hearing on a motion to suppress. You're all set, Mr. McNeil. Thanks, everyone.
Thank you, Your Honor. Thank you, Madam Clerk.
You're on to number 17 on the list, Commonwealth versus Caleb Adames. Mr. Adames present. Your Honor, for the record, it's indictment 2025-0143. It's scheduled for defendant's pro se motion to modify conditions of release. I don't see Mr. Adames present in court.
Good afternoon, Your Honor. William O'Driscoll, the Commonwealth.
Okay?
This was scheduled last week at the defendant's request. I received a phone call this morning from P.O. Flanagan saying he spoke with Mr. Adames, and Mr. Adames indicated he was unable to make it today as he did not have a ride.
Okay.
That's all the information I was able to receive from P.O. Flanagan.
Okay. We'll leave it up to Attorney Wayne or Mr. Adames to notify the court and schedule another time.
Thank you, Your Honor.
Okay? Very good. Thank you. Let's do one of them, and then we'll do the other.
Okay.
Okay?
Can we have, Ms. Powers, please? Ms. Powers? Your Honor, for the record, this is number 14 on today's list. The Commonwealth versus, where'd you go? Brandy Lynn Powers. Ms. Powers is represented by Attorney Patrick Kelly, the Commonwealth by ADA Jill Martinelli, docket 2024-0054. Defendants in custody, she's being brought in. Counsel, while we're waiting, if you could identify yourselves for the court and the record, please.
Good afternoon, Your Honor. Again, Joe Martinelli for the Commonwealth.
Okay,
Good afternoon, Your Honor. Patrick Kelly, Ms. Powers.
okay. This is on for a lobby, but I'm not sure it's useful to lobby a case like this, given there are mandatory minimums. Have you folks have any kind of an arrangement or deal?
Not yet. We have discussed a potential resolution, Your Honor, but...
Would it be helpful to lobby with the court?
Sure. Yes.
Okay.
Your Honor, for the record, Ms. Powers is entering the...
Okay, Ms. Powers, counsel's indicated that they had some, thought it would be useful to talk to the court about lobbying the case, so a possible resolution of the case. So they're going to come to the sidebar in just a second, and you're welcome to have a seat while you're waiting.
Matters held for further call. Are the parties on the first call ready for further call?
Yes. Thank you, Madam Clerk.
You're on a further call on the matters of the Commonwealth versus Johnson, De Los Santos, Chianchio, Walsh, and King. Is that everybody?
I think that is,
He is. Okay. Thank you.
Your Honor, can we approach?
I beg your pardon?
Could we approach?
Yes.
I don't know how Mr. Kitchen's going to do that.
I don't either.
And that, we could discuss that at sidebar.
Okay? Mr. Tipton, to the extent you are on Zoom? Mr. Tipton, are you there?
Technically here, but I don't see him. I've asked him to, oh, there he is.
Mr. Tipton, are you there? Mr. Tipton, are you there?
Text him, Judge, if you want.
Hang on one second. There you go.
There he is. You're still muted, Mr. Tipton.
Mr. Tipton, can you hear me? Just give me a thumbs up if you can hear me. All right, we cannot hear you. But we can see you, and apparently you can hear me. Ms. Beatty just asked for a sidebar. We went to the sidebar only to discuss enough whether it should be held at the sidebar, and I decided that there was no reason to have it at a sidebar. So that's all that happened at the sidebar. You missed almost nothing. So let's hear. Oh, there you go. Now I can hear you. That's great. So let's try an open court. What's going on?
And certainly I offered to convey to Mr. Tipton anything that happened at the sidebar, and I will have a conversation with him after court today.
Great.
As can able defense counsel who are present here as well.
Okay.
So before we recessed, the court had posed that there was sort of a binary point at this point in these proceedings, that there was one where the Commonwealth informed the court that they had materials to produce, and one, or that they wished to produce, and one where the Commonwealth conveyed to the court that they did not find any materials that they wished to produce. And I'm telling you right now that I am not representing to the court the second, that we do not have any materials to report. I'm explaining to the court that we are in communication, and
I think there was a double negative in there.
there was.
You are not representing to the court that you do not have information to turn over.
Yes.
So having done the review,
Yes.
it's worth it for you to go to other locations to try to get information, try to convey the need for you to turn over information which you believe to be discoverable under Rule 14.
We are continuing to have conversations and negotiations with the U.S. Attorney's Office, and what steps we take from there, I don't know at this point in time, but we are working with our counsel at this point in time.
Okay.
And I'm happy to come back to court at any time that's convenient for the court as well as for defense counsel. We're especially mindful not only of the date in the order, but also of the Walsh trial date.
Okay, so we have a return and destroy date of October 21, 2025, and Walsh is supposed to be tried starting around that time, maybe a little earlier than that. So, when would you like to be back? Yes.
I'm just very concerned that we're 25 days into this 60-day destruction order. And I'm concerned that if at some point, this board needs to make order, we want to make sure that I just want to make sure that we're giving the Commonwealth enough time to do what it has to do. We can't do what happened initially is, you know, the day before making phone calls saying this stuff is getting destroyed tomorrow. So I'm just concerned that we're 25 days in, we're 35 days away from the destruction order. And as far as I can tell, we're not very far advanced as to where we were 25 days ago.
Well, 25 days ago, the Commonwealth hadn't reviewed the materials. It had just gotten the order from Judge Casper, and it's now reviewed the materials as it relates to all the cases that are currently before me. And it's made a determination that it needs to go to the U.S. Attorney's Office or the federal court to get authorization to make a disclosure. I think we have had a lot of progress in 25 days, and
to the extent that they can't get that information, Judge, I'd want some sort of heads up that the federal court said no, or they're not going to do anything. I don't want to be in a situation where we're waiting another 2 weeks and then the answer is no. And now we're behind the 8 ball again. That's what I'm trying to avoid, Judge.
all right, well, in 2 weeks, we will not be behind the 8 ball. In 2 weeks, we will have more information, and I'm happy to revisit this in 2 weeks. That still will be plenty of time before the destruction order, and before October, the destruction order, that would give us 3+ weeks before a destruction order for you or others to go to the federal court to seek additional remedies. So, unless somebody thinks so I should put this on for a different time frame, I will put it on for 2 weeks from now.
I'll just, Judge, if I may,
Yeah.
I would just weigh in and ask that it be put on a shorter leash, a week's date.
What's going to happen in a week?
I mean, what's a reasonable schedule? If you've made the determinations that you've made, you've got to get things on file in the federal court, or those discussions have to be expedited, particularly given the schedule for Walsh.
Either one of those is fine. Obviously, a week is less time to accomplish things than 2 weeks. So if Mr. Tipton wants to come back on his own in 1 week, that's fine also. I appreciate he has a different schedule perhaps than other people. It's really at the convenience of court and counsel.
Well, much depends on how much can be accomplished in a week. I mean, have you have the discussions with the U.S. Attorney's Office begun?
Yes.
Okay. And do you think that they're likely to bear fruit in the next week? Do you have a meeting scheduled?
I have found that
deadlines matter.
and that I believe them to be acting as quickly as they are able to respond to our inquiries.
Okay.
But, you know, 5 days is 5 days and 10 days is 10 days. Everybody has lots of different things that they're dealing with.
Sure.
And there's not unlimited time.
What is the Walsh trial date?
The 20th.
The 20th. Okay. Let's put this on for the 29th.
I can't do the 29th. I have an all-day evidentiary hearing in Suffolk that involves Bob Sheketoff.
Okay. Can someone stand in for Ms. Capiccio on that date?
I started trial on the 29th, Your Honor.
You're on trial on the 29th. Okay.
We do the 25th or 26th?
We could do the 25th, but only in the morning. We could do it at noon.
Can't do noon. I have to be in on a final pretrial for the case that I'm starting.
What time's your final pretrial?
2 o'clock.
9 o'clock? Wait a minute, your final pretrial is where?
Suffolk.
Oh, so we could do noon.
Yeah. I'm happy to drive that.
Noon on the 25th?
What day
I
is
could
it?
do noon at 25th.
25th is Thursday.
Thursday, the 25th? Okay, thank you.
May Mr. Johnson behaved in, Judge?
Sure.
And on behalf of Mr. De Los Santos and Attorney Krowski, I think he would want his client here as well.
Giancio, be excused, please.
Yes. Ms. Chiancio will be excused. And on the will be 25th at noon.
I thought we said 9 o'clock, so it's actually in Suffolk at 2.
I'm sorry?
I thought we said 9 o'clock, it's actually in Suffolk at 2.
No, we said noon, and you'll definitely get to Suffolk by 2. Easy. Easy.
Okay, good.
Oh, we're gonna be here for 20 minutes, right? All right.
Then 45 minutes now, and we still don't have any answers, so.
All right. Remind me that you have to be in Suffolk at 2. We'll call you right at noon.
I appreciate that.
Okay?
Thank
All
you, Your
right.
Honor.
Okay,
Madam
thank you.
We do have some individual requests for Mr. Johnson, that I think we addressed somewhat last time we were here.
What was that?
One of them is Colin's looking for Rule 17 for the victim's medical records. We don't have any objection to that, Judge. I can't imagine Attorney Krowski has an objection to it, and I know that
No objection.
we don't have any objection. They're the victim's medical records. They come in, they're going to get them.
It was already filed.
Probably impounded. I'll have to go get it out of the vault. I don't have it up here. Do you want
I
it?
wanted to ask that that motion be heard, on the next date. I have to give notice to the hospital.
Notice to the hospital?
Yes, it's for Boston Medical Center records. I subpoenaed them. I've been trying to get them. I subpoenaed them to grand jury. I've had next of kin sign HIPAA form. I'm asking for a court order for those records.
I'm hard pressed to understand why I wouldn't sign the order now. The privilege holder is deceased.
Yes.
Prepare an order and send it to me.
I believe I attached them with my file.
Do you know what the filing docket number is?
I can,
I just want to make sure we definitely have it. If we don't have it, the clerk will note.
I can email another one.
Yeah, Ms. Irwin can get in touch with you if we can't find it, and I'll get it signed.
Thank you.
Okay?
Judge, the only other issue, last time we were here, I indicated there was some late discovery in Mr. Johnson's case. I did send a very detailed letter to the prosecutor regarding all of the late discovery. We did have a conversation on Friday regarding that. She's still working through that late discovery. I think we're going to probably have an agreement on what's late, which would include 14 or 15 search warrants and a bunch of other things that seem like it's very similar to the King case. So we will be filing a motion requesting bail, Judge. I just wanted to let the court know that.
All right, we'll see when we get it. Okay, thank you.
Thank you.
these matters were all continued to September 25th at noon. Process will issue as requested. Thank you.
Thank you.
Jennifer, I don't have it, Did you say you filed it? I'll look. If I don't have it, I'll email you. Thanks.
All right.
Your Honor, the remaining matter on today is in the matter of the Commonwealth versus, is it Curtis Sullivan?
Curtis Giles,
Curtis Giles.
and then we have to do the second call on number 14.
Oh, that's right. It's indictment 2025-049. It's on for a lobby this day. Mr. Giles in custody. Oh, no, he's present. He's represented by Attorney Scott Murphy, the Commonwealth by Sir, thank you.
And I think the docket is 2546, not 49. Okay?
Yep.
All right, this case is on for a lobby. Do you want to lobby the case?
We can't today.
Council and I are on pretty much the same page. I have supervisors I need to, meet further with. I have met with them, I just have to do further work regarding that. But, we've had very productive conversations regarding possible disposition.
Does it make sense to put this on for a change of plea?
No.
I'm sorry, what you said?
I said no.
No.
How much time do you need to run things up the flagpole? A week? Mr. Murphy, when are you back?
I'm on vacation as of Friday for 2 weeks, so I'll be back on October 7th.
All right. How about the 9th at 2?
That works.
What are we doing that day?
That'll be a lobby conference, 10-9 at 2 o'clock. Is your last name Giles? Am I pronouncing it correctly?
Yes. Yeah.
Okay, Mr. Giles, all right. Okay, very good.
Sir, your matters continue to October 9th at 2 p.m. for a lobby conference. You're all set, sir. Thank you. Thanks, everyone. The party's ready for second call on Powers.
Mr. Murphy? Kelly, okay.
Take a break.
Is that everything?
I think that's everything, Your Honor. Oh, great.
Okay.
Do you want your client brought in, Mr. Kelly? Please. Can we have Ms. Powers again, please? Thanks. Is Mr. Sullivan all set? Does she have a case? Do you have a case you're looking for? Sure. Oh, great. God bless you.
Bless you. This would be a plea only on the last count.
Oh. And the others are all dismissed?
Yes. So it's count 6, Class B.
Your Honor, Ms. Powers is back in the courtroom.
All right. Mr. Kelly, what are we doing today?
Seeking to resolve the matter, Your Honor.
All right. And your client's intending to plead guilty to count 6, which charges possession with intent to distribute Class B, DeWitt cocaine, and in exchange for that plea and a recommendation by the Commonwealth for a 1-year probationary sentence, the Commonwealth is prepared to dismiss the remaining 5 counts. Is that correct?
And the Commonwealth will be moving to amend that to possession of cocaine.
Oh, simple possession?
Yes, Your Honor.
Okay.
Your Honor. She is prepared.
And is the Commonwealth recommending certain conditions on the 1-year probation?
Yes, Your Honor. We had discussed, and I think this has happened quite quickly, a possible program. Based on the fact that I don't know if counsel is able to have one lined up at this moment, I just asked that Ms. Powers be drug-free with testing. Or in the alternative, undergo a substance abuse evaluation and follow up with any aftercare, if that's...
Well, and what kind of a program were you thinking of?
For drug treatment, Your Honor.
Yeah, but were you thinking of residential? Were you thinking of an intensive outpatient program?
I don't know what type of availability at this point would be lined up. I'm amicable to an outpatient program based on the facts, circumstances, and the quantity in this case. But so as long as she was testing, I'm content with an outpatient as well.
Does Ms. Powers have a place to live?
Yes, Your Honor. Well, yes, she's staying with her grandmother in Dorchester if released.
And that's where she'd be living if she were on probation?
Yes.
All right. here's my concern, and that is that Ms. Powers gets out and she uses again, and that's my concern, okay? Oftentimes somebody who's been in for a 2-week or 3-week leaves, uses, and overdoses. And Ms. Powers, if I'm going to impose a 1-year probationary sentence, I want to make sure you successfully complete the 1-year probation. You understand?
As do I.
Good.
They did put me on a program, while I was incarcerated.
Well, that's good, but you haven't been on it for very long,
Fair enough.
okay? Mr. Kelly, who else lives at the residence with the grandma?
Just the grandmother, Your Honor.
Just grandmother. How long would it take to get Ms. Powers into an IOP?
Your Honor,
Would take 30 days?
depends on the availability, spots available at an IOP. I can't say that for.
Are there IOPs in the Dorchester area?
Yes, I believe so.
Mr. Kelly, was your client working before she was,
No,
she came in?
not too recently, no, Your Honor. She hasn't been working.
I don't want to be overly interventionist here, or overly cautious, but I'm really concerned about Ms. Powers coming out. I'm inclined to say that she should live with her grandmother in Dorchester, that she should remain in the house until she can get into an IOP. 30 days is a long time. I would want it to be a lot less than 30 days, okay? But I want you to have the support that you need, Ms. Powers, so that I know that drugs are an issue, right? And that's what I've been told. And I want to make sure that you have the support when you come out to be successful and to stay clean. Is your grandmother here?
No, Your Honor. She has family, but the grandmother's not here.
How would you get to your grandmother's house if you were released today?
My sister.
Your sister would take you. Well, Mr. Kelly, what do you think about that, which is that Ms. Powers would be at 1-year probation. She would be on home confinement at grandmother's house until she can get into an IOP. She'll have every interest in getting into that IOP quickly. Probation will have every interest in getting her into an IOP quickly. And then she would be in an intensive outpatient program. She'd be required to be drug-free, subject to random testing.
So, Your Honor, I think it makes a great deal of sense. I certainly understand the court's concerns for a worst-case scenario. I think Ms. Powers, her own concern is that, well, she's confident she could go to her grandmother's for the very, very short term because her grandmother lives in, I don't know if it's Section 8 or elderly housing, that any extended stay might get her grandmother in a bit of trouble. So I don't want to, more importantly, she doesn't want to set anybody up for something that's just not going to work out days or weeks from now.
Well, I appreciate that, and I think that's good, an important concern. Does Ms. Powers have another place where she could live?
That's my knowledge.
It's also the issue of a warrant out of Lawrence District Court. Looks like there may be a warrant out of Quincy, too.
The Quincy case, may have been, no process subsequent to her arraignment on this matter.
Okay.
But the Lawrence case certainly remains in warrant status. Not to get too far down the road, but if
Yeah.
ends up with Ms. Powers on probation, my final request was going to be as a condition for her probation, for the court to order her to report to Lawrence. She does have a ride there tomorrow, but that might be getting a bit ahead of myself.
It looks like Lawrence is a simple possession Class B case, but still in default status, a warrant is issued. Well, given that Ms. Powers doesn't have a place to live, what would you suggest that I do? Other than for a very short time.
I think stepping it back for a couple more days to just get something more stable lined up would make more sense, Your Honor. I don't know if Ms. Powers was and myself and counsel hadn't discussed the plea happening today necessarily. These are the conditions we would hope for. I think Your Honor understands where we're trying to get this as well, but I do have the same concerns that I think we'd be setting up Ms. Powers to fail without any stable conditions.
Another option is a sober house placement, where Ms. Powers would have to reside at the sober house. She'd have to get tested at the sober house. She'd have to participate in their programs, abide by their rules, and if she was sober after 6 months and she was successful in that program, we could step it down to she could be released from that program and subject to the no drugs and alcohol and a random testing condition. That might be a possibility and allow her for 6 months to get her legs under her when she gets out. Without breaking any attorney-client confidences, your client seems to be nodding her head at you in that regard, Mr. Kelly. But I want to make sure that there is an appropriate halfway house sober house placement that we could get Ms. Powers into. Any idea about that, Ms. Boyce?
Yes, Your Honor. She should have a case manager going to her in custody, and they can help with placement for sober houses before she goes.
How long do you think that takes? A few days. All right, Mr. Kelly, what do you think?
So I know Ms. Powers started off the conversation by saying she's in a program of some sort at the jail. I think it's the case manager, the same individual who hopefully can line up something. I'd be lying if I said I have even a good guess as to how long this takes. So
okay.
Assuming the next date is in order, I just don't know what the best bet is in terms of scheduling it.
Well, what would you think about this? I schedule this. Here's the difficulty I have. I'm out the 23rd and 24th and 26th. And I only have the morning, well, I guess I have the late afternoon too on the 25th, but it's tricky. I've got to be in Boston from 1 to 2. So, I could put this on for a hearing on, say, that on Monday the 22nd. I don't know if you're available on the 22nd.
I'm here.
You're here, so I could put it on in 7 days. You could work with the case manager, talk to probation, see what you can work out in terms of a halfway house or a sober house placement. And I'm happy to hear you then. If you can accelerate it and you've got the information sooner, you can bring the case forward and I can hear you any day this week. But that might make sense in terms of a schedule.
I can reach out to the drug court in Quincy and see if they have any recommendations.
Well, Quincy's not going to help us. We're talking about Dorchester, but, well, I don't know. Maybe not. Maybe Norfolk makes sense. Being a little away from Dorchester might make sense. That's not a bad idea. I think reaching out to Quincy makes sense. Sorry to be speaking so stream of consciousness here. I'm working it all through. Okay, anything else? Okay, we'll see you Monday. All right, or sooner if you bring it forward. Okay, thank you. Thanks, Ms.
Matters
Boyce.
continued to September 22nd at 2 p.m. for possible disposition. Your Honor, that concludes today's work.
Great.
All right.
Right here, it's two. You know what I was thinking? I don't know if she can do it, but if she can get in the lawn, we can get rid of that. All right, and then it's not sitting on a pretty easy for the other people. Yeah.
Maybe Zoom or something.
Something, if they can put, if they put in the trial request, just put the, no. I know.
Yeah, that's okay.
Yeah, it's lawn, so.
You told that?
Can you know about lawn for us,
Well, you might be sitting on both.
I feel like we might get stuck in the same thing if we don't.
I know.